Yeah, anybody else wants to unmute and introduce themselves? I see a lot of them. I haven't.
Welcome all for this lovely session of
Yeah. I see a number here ending with 0826. Can you unmute and introduce yourself? Hi Sai, hi Usha, hi Sridhar, hi Shirisha, hi Kevin.
Hi, Julian.
Hi. Welcome all to the webinar session. And if NB, okay, if you can unmute and introduce, that would be good. Okay, I guess we can start now. Is that okay, Alexander?
Yes, I'm ready.
Yeah, sure. So we'll just so yeah, welcome everyone to this session of our Let Us Talk It webinar series. From June, we have started this on Tuesday, Wednesday, and Thursday, and we are very excited with the topic that we have today. The topic today for Let Us Talk It webinar is H-1B program in the crosshairs. Trends and concerning policies for the most popular work visa in the US. I think right now, nothing more than this topic is important. And to talk about this, we have a principal attorney, Alexandra Mikhailov, and she represents clients across an array of industries, including technology, startup, and emerging growth companies, as well as large corporations, small businesses, and nonprofit organizations as well, in a wide range of immigration matters. And clients turn to her when engaged in the domestic and international transfer of foreign personnel, including executives, managers, and other highly skilled professionals. And a little bit more about Alexandra. She delivers exceptional results for clients for sure. And clients note that Alexandra is a fantastic, passionate, dedicated, and knowledgeable attorney. Her record of delivering favorable outcomes on employment-based immigration benefits, corporate compliance, and family-based immigration matters has gained her recognition as a rising star on the list of Washington, D.C. In 2017 and Super Lawyers and Bethesda Magazine Top Lawyers in 2019. And after graduating from Georgetown University Law Center, Alexandra practiced in a prestigious international law firm in DC and was also chair of an immigration practice at a mid-sized side law firm before starting her own law firm. And the fun part of it is that she also likes hiking and been trekking in the Himalayas in Nepal, Inca Trail in Peru, and Japan. And for sure, after reading that, I thought you should have another session just talking about trekking. We are so honored, and absolutely, it's a pleasure to have you, Alexandra. Over to you.
Yes, thank you. Thank you so much for this nice introduction. I'm just delighted to be here. Thank you everyone for joining us. We have very exciting topic. Like Julian said, everyone is interested and honestly slightly concerned, right, about what's happening with the administration, what are the plans, what will be happening. So I will explain what are the plans. I just want to make sure that what we are discussing today is sort of the planned executive order and any regulatory changes and the changes that will be happening in the US. They are just based on a leak from the White House, right? So nothing is formal, nothing is published, nothing is released. We just, the immigration community, a few immigration lawyers have access to someone who is sort of providing information about the behind the scenes.
Mine or yours?
Yours.
Where's yours?
Oh, mine's in the car.
This is yours right here, yellow, right?
Yeah, but mine's in
wanna
the
mute
car. I have another one.
Do we want to mute everyone, please?
I'm so sorry. Yes, I muted everyone.
Thank
Please.
you.
Yeah, thank you. Sorry about that.
That's fine. That's fine. It happens all the time. So the word of caution that, we are talking about what's happening behind the scenes in the White House and Congress, but nothing is formal or published. So keep that in mind. We will also discuss what you can do at this point, even when nothing is formalized or published. So thank you again for the invitation. I'm delighted to be here. Julian already introduced me, but let me tell you just a little bit more. So Alexandra Mikhailov, immigration attorney. I think Julian explained the type of cases that I do, really mainly business immigration. That's probably what we do. 80% of our cases are business related immigration support, and about 20% is family-based immigration. We work with corporations on work visas, H-1Bs probably being the most common, L1s, E2, TN. We do work with extraordinary individuals who are on the O1 visa. And then we also provide support for green cards. So when someone is working on the work visa, they transition to the green card, so perm application, different type of I-140 support, EB1, EB2, EB3, just really depending on the type of credentials. So I would say across the business immigration, we do pretty much everything. You can provide any type of support. A few things we don't do, and I'm sure that no one in the audience sort of needs that kind of support, but we don't do asylum, we don't do deportation cases, removal, it's sort of almost completely different type of immigration law. So we are located right outside Washington, D.C., just 15 minutes from Washington, D.C. in Bethesda. I'm providing here my email address, my phone number, and also my Twitter handle. So Alex Mikhailov is my Twitter handle. And we sort of try to be very active in the immigration community, especially now, but honestly, always a lot of things are happening in the immigration world. Under the previous administration, sort of a lot of good was happening. Under this administration, a lot of bad, unfortunately, things are happening, but we try to be very active and monitor that and really report to our clients and friends. So I do that on Twitter, and we also have a very good, the clients say that it's very good. It's not my word. The clients say that we do have a pretty good newsletter, that we try to analyze the news and really put them in the very easy to digest, not legalese, just a language that sort of, is understood to someone who is not practicing immigration, also analyzing the implications. What are the implications for the individuals who are in the process? So we hear from the clients that they always say, well, we read only your newsletter, or maybe just a few others. So if you were interested, if you sort of trying to stay on top of what's happening, what will be happening, then we invite you to stay in touch with us. So thank you again for joining. Let me start here with So this is a little bit of the outline, very short outline, but we're gonna expand on it. So we're gonna discuss two different avenues of what's happening with the immigration right now, and especially affecting H-1B work visas. We're gonna talk about a possible executive order. So that is something that President Trump is really considering, and that's what we hear behind the scenes. Again, it's based on the leak, but very credible. This is really happening right now in the White House, that they are drafting that executive action that will be affecting H-1B visa holder, L-1Bs, J-1. So we will talk about the possible timing, possible restrictions, who is affected, who is not affected. And then the second part of this call or webinar today would be to talk about the regulatory changes, so the ones that actually require Congress. So as you know, executive order is something that President Trump can sign today, you know, in the White House, that he can go in front of the White House and just say, you know, this is my executive order. It's effective from midnight today. So that is something that is just effective immediately. So that's the one part that we will be talking about. The second part, in the later part of the call, we will be talking about the regulatory changes, the one that require at least 6 months. The administration really does not have that much time, right? Because if you look, we are already in June, the elections are in November, but you know, the president, if it's the same president, then you know, we still have 4 more years. But if we have a new president, then President Trump can still sign anything until his inauguration day. So they really have 6 months, and they will be doing changes in the regulations too. We will see if the regulations are something that sort of they are careful, that they really think about them, meaning that, you know, if someone is taking them to court to sort of strike it down, that it might be hard to do. Thinking about how little time they have, they probably will just try to pass and do any regulations, whether they are good or not, just to make it difficult, right? Because this is, unfortunately, this is the type of administration that is making life difficult for immigrants, and we know that is part of their policies. So we will also talk about the changes that we can anticipate, but again, keep in mind that this is more long-term and it's not right away. So this is the executive order that you are probably, if you are on H-1B visa, I'm pretty sure that you heard about it. That's suddenly last week, there was a lot of concern that this executive order, or EO, if we can shorten it, that it might be signed on June 11th. So it was anticipated that it might be signed on June 11th. It wasn't, but it doesn't mean that it's not going to really come out. So a lot of, you know, visa holder, H-1B visa holders, a lot of immigrants, immigration communities are just saying, oh, you know, if it didn't happen on the 11th, then maybe they change their minds. No, we hear that this is still very much on the table. It might be signed in the next 2 weeks, so really the last 2 weeks of June, which when I'm looking now at the calendar, so we have 2.5 weeks, or 2 weeks right now. So pretty much any day right now, we can anticipate this executive order to be signed. And again, that's the one that President Trump can stand in front of the White House and just say it's effective from midnight. And then sort of the bottom line of this executive order is, the third bullet point that I have here is not allowing entry of certain foreign nationals to the US. The president really has that power. That's one of the few powers that he can do without involving Congress, without sort of just really passing any regulations. He can not allow certain individuals to come to the US. And he has done it a few times already, and he is using the section 121F of the INA. And this section says that president, as the executive, he can keep a person or a group of people outside of the US if that is in the interest of the United States. Interest of the United States, right? So that is something that he is using. He used it on the Muslim ban. That was something, when was it, 2017 or 2016, when he said, you know, we feel like there is a greater risk that some of those people might be terrorists. And that's actually how he won in courts. Based on this section, And the courts allowed him. There was a lot of litigation, very lengthy litigation, but administration won it. That's why we still have the travel ban for the Muslim countries, right? Still the individuals from those countries, they cannot come to the US because he was able to pull some sort of reports that said, yes, you know, maybe it's a little bit higher increase of sort of people involved in terrorism in those countries, and we do not know how to filter them, and we really do not know, you know, even if the whole nation is very peaceful and nice. So that's one of his basic powers. So he is using the same argument right now for the H-1B. Obviously, he's not saying that the H-1B workers are, you know, any type of bad people, but he's saying that this is in the economic interest, because suddenly we have a very high unemployment. We have 20 million people, most of them are Americans, without jobs. So he's saying, in the interest of the United States, I really have to keep the US workers, the foreign workers, certain foreign workers outside of the US, not allowing them to enter, because I am concerned, me as the president, I am concerned about the US workers finding the jobs first. The president and the administration, any other previous administrations, they have never used that provision, the section 212F of the INA, they have never used it for economic argument. It was always safety or, you know, health, right? For COVID, like now, almost no one from Europe can come to the US still. Obviously, that's more understood because we had a pandemic. So the president used it for several, based on different arguments, but he has never used it based on the economic grounds. Now that I'm recalling that there was something in the courts in the Ninth Circuit that he tried to do it, but he was not successful. So that one was struck down. But again, you know, he has the right to implement it. If he does, it's going to be in effect until the legal system and the courts strike it down, which might be a very long period of time because the courts take a long time. And even if the president and the executive order says the order is only for 90 days or it's only for 120 days, it's really, you know, I would not be counting on it, right? Because every single ban that we had so far on different individuals coming to the US was also, the Muslim ban was also supposed to be just for 90 days, but they never review it. They never sort of reconsider that, except I think for some countries, they just removed Iraq, I think, from the list because we had some sort of relationship with them. But if they say, you know, we are banning now all of the H-1Bs and L-1s and J-1s from coming to the US, then that order is going to be in for a very long time, even when they say 90 to 120 days, until the courts strike it down, or really that the administration would just reconsider it, perhaps based on some good economic news, right? So if the unemployment suddenly was changing, if everyone who lost the jobs in the last 4 months, if they were rehired, then that definitely perhaps would lead it to maybe removing that. But I doubt it because this is just election year too. So you're gonna have election in November. So I doubt it that anything would change if they really will implement it. Let me just pause it here so I can look if we have any questions here. So I wanted, when I was discussing the program for today, or what we're gonna be discussing, I also wanted to say in the last few minutes, I'm gonna leave it open for you to send your questions. You can either ask them by unmuting your phones and just telling them to me, or perhaps you can send them through us by the chat or Q&A, so then we can screen them. We will answer only questions that are sort of helpful for everyone, right? So we cannot answer questions, you know, my personal situation, I have an H-1B and so forth and so forth. We just try to do it on the, just something that would be helpful for everyone that is on the call today. So we will get to the questions a little bit later. Let me just see here. Okay, so now we're going to talk about the restrictions, the specific restrictions for the executive order, right? The one that it's going to be in effect immediately. So it's H-1B, H-2B, L-1, and J-1 visas. We're going to talk specifically with J-1. I don't know if we have any individuals on J-1. There are like 15 different categories for J-1 visas. So not everyone is affected, but some are affected. So right now, so what we are hearing is that the spouses and children, so derivatives, are not affected. So that is a lot of concerns for H-1B workers who are now in the US, but perhaps your wife and children are in the home country because they were not able to come back because of the pandemic, or perhaps they already left because they wanted to spend the whole summer in the home country. So we are hearing that in the current draft that was made available to us last week, that the derivatives, spouses and children, are not affected. So if they are outside the US right now, if the executive order was signed today, they could still come back unless the principal is also affected. So for example, if the whole family left, if the H-1B worker with spouse and children, they all left and they went for 3 weeks to India, if the executive order comes during your trip, then no one will be allowed to come back. So really that executive order, the one that is affecting, is just based on entering the US. There is nothing else because president cannot really change anything else. So it's not going to affect anyone who is in the US. Again, as I saw on the previous slide, I'm sorry, something is happening in my office. So the president can really only sort of affect the employees or the individuals who are outside of the US. That's the power that he has. That's why we were saying, and we were advising the clients, and we are still advising the clients really to come back. I don't know if we have any, I think we mostly have individual employees on the call today, but if you have any colleagues or if you have employers who have a large population of H-1B workers, we do want to get them, you do want to get them back to the US because, again, especially the principal employees should be in the US until we know a little bit more about that executive order. And that's, you know, I hear so many different concerns about this executive order. So just to sort of, that is really not allowing the individual to enter the US for economic reasons, right? That is the proposal. I'm not gonna allow the individuals who have H-1B to come back to the US. If they're outside right now, I'm not gonna allow them to come back because I am taking care of the US workers who lost their jobs. And that is my main concern. And specifically the H-1B cap cases that were selected this year, and they are waiting still outside of the US, right? So again, outside the US is the keyword here. They are specifically targeted. You know, 65,000 H-1B cap cases. I don't know how many of them are in the US and how many outside, but I bet it's at least, you know, a quarter of that, or probably more, a third or half of them are outside, right? Completely brand new cases that that companies are filing for this H-1B. So those individuals, if you have the H-1B approval notice, if you know someone who has H-1B approval notice for a cap case and maybe still waiting for the decision, maybe it was already approved with the October 1 start date, if between now and October 1, this executive order comes in, then you are affected. But if we have a new president in January, then we are hoping that if Biden is a president, then that will be really the first order that he's going to remove. So hold on to that H-1B approval. It doesn't mean that your approval was invalidated. Your approval is perfectly valid. It was approved by USCIS. That means that you can still just get a visa stamp and come to the US. You were not allowed to enter simply during this period of time. So really the timing is going to be very short, right? And then just really depends on the outcome of the election, what's going to happen in November. L1 visas are also going to be affected, L1A and L1B. L1A is for multinational managers who were supervising or managing teams outside of the US, and they coming to do it here in the in the US and abroad, and L1B is for specialized knowledge. So as I noted here, it's a very dangerous group to take on because I mean, when I work in a big international law firm, we were doing constantly a lot of L1 visas for multinational companies, almost every single company that has offices somewhere outside of the US, and really Fortune 500 companies, almost all of them have it. They are using the L1 visas. They do not rely on the H1B. They rely on the L1 because they can bring anyone on the L1 much faster. They are not subject to the quota. And that really works for the operations. So taking on the group of executives that they are not able, even if they are here, they are not able to leave and let's say manage a team or go for a business trip to Europe because that is part of their job duties. So you just either restricting them from coming to the US or you're not allowing them to travel, which is part of their job duties. So the immigration community of the immigration lawyers are just really thinking that this is very dangerous group to take on. There's going to be a lot of unhappy people, and big international companies can do a lot of things to make life a little bit more difficult for the administration, including, closing the plants, closing, I don't know, some sort of blue collar jobs in the US or moving them somewhere else, something that the administration is really very keen on keeping. So it's possible that it might be only the L1B, the specialized knowledge, which is for people who are sort of similar level like the H1B. They are doing specialized work and not include the L1As, but we're not going to know until the order comes. The J1 visas very quickly, because I don't think we have any J1s on the call today. So they just want to exclude the work summer program and camp counselors and interns and trainees. The first two, I think it's not an issue because there are no camps, as far as I know, this summer happening anyway. I don't think there is any, summer work. We do have travel ban for people coming from Europe due to the pandemic. So I just wouldn't see that this program being active this summer anyway. Interns and trainees is something that I think the administration had a perception that perhaps they were just a little bit abusing sometimes the system, sort of skipping the H1B, they'll just get them as intern and trainees and pay them less. So I think that's why they are attacking this part of the J1 program. The scholars, researchers, and doctors are exempt or should be exempt. We are hoping that's really people that we need here. And there is also something in the executive order that says the competitive recruitment exemption. No one knows what it is for sure, but the immigration community is really hoping that it means that H1B visa holders who already went through the PERM system, already went through the PERM process, that means there was competitive recruitment for their position, right? Because for the PERM application, you need to place the ads, you need to really do all of this recruitment to show that there were no US workers interested in your job. So we are hoping that that would include the individuals who are the PERM approved and they would be under this exemption because obviously a lot of H1B workers have the PERM approved and that would sort of free them up from being included in an executive order. How do you do that when you go and you say, yeah, I do have PERM application approved, so now I'm gonna travel and I'm gonna come back. What is it, gonna be showing your PERM application at the CBP booth when you're coming back? I have no idea how they're planning to do that. But yeah, just keep in mind that there is that exemption, which is sort of a little bit positive and makes sense because yes, there were no US workers. If your PERM was filed, if you know the immigration attorney or your company went with the PERM filing, that means that there were no US workers that were qualified for this position. Okay, let's move to the next one. Okay, I'm gonna. So now we're moving to the second part of the changes, the anticipated changes that we are thinking on knowing or sort of anticipating. It's not the quick one. It's not the executive order that can happen just overnight and they're gonna say, president will say, I made this few changes and now they are effective from tomorrow. This rules, these changes to the rules require time and there is really no other way to do it than go through the process, and that takes 6 months at least. As we were speaking administration almost doesn't have that much time. So the few changes that the administration is contemplating is to remove that STEM OPT extension that was, and then put additional requirements on the first 12-month OPT program. So right now the 12 months OPT program is, I think it works great. It just provides the enough. It's just that usually the individual and the school are involved. The employer is not that involved. It's not really intensive on the employer, which I think it's easier for the individual to find a job for those 12 months. So there are changes to implement additional requirements. I would think probably something along the line with, like a training program, just a little bit more reporting, maybe something like we have on the STEM OPT portion, where the employers have to be a little bit more involved. And obviously rescinding the whole STEM OPT would be big news and just terrible news for the individuals affected. Right now, those individuals who are graduating in the STEM degrees, they have additional 2 years, they have additional 24 months. First of all, it is helping them with multiple tries to file the H-1B cap case, and just gives you time to get to know your employer, perhaps engage in a conversation that I need sponsorship. And obviously just 1 year of OPT, you might not have enough time to file the H-1B cap case if you wanted to stay here. Or sometimes you might not make it in the lottery. So the STEM OPT, removing that, I heard it for a very long time. They have not forgotten it. It was on the shelf. It almost feels like they are just leaving this for the last few months of the administration, thinking like, yeah, it's now or never. Now we're gonna do it. If they also do not know who is gonna be the president next year, so they're gonna touch all of the issues that they wanted to do for the last 4 years. The next one is also the H4 EAD, right? We heard about it for a very long time. It was sort of back and forth for a very long time. That is something that they still dislike it. They still do not want this, and they want to remove it. So that's part of the things which I really feel like I was reading an article recently about the H4 spouses, which removing those EADs, like you cannot find another word than just being cruel, like especially for Indian nationals who are waiting for the green card for so long. Congress is not doing anything to change the rules on the per country limits, increase the immigration limits. So removing that H4 EAD, it would be just a sacrifice on behalf of the spouses. I don't know, that is really touching me very closely. So changes to the H-1B program. So they're going to be more, it's not going to be anything drastic. So it's not going to be suddenly like, oh, now you cannot file H-1Bs anymore, right? Like we now do not want H-1Bs. They're taking our jobs. We need these jobs for the Americans. They cannot do anything like that. The few things is just they can make it to make it tighter, even tighter. It's already tight. They want to make it even tighter, and they can concentrate on a few things. They are concentrating on those things already. Employee-employee relationship. That is one of the big issues that we are seeing in the cases that we filed and the RFEs that we are getting. They are questioning, especially for a client placement, right? When someone is working at a different location than the main employer office, they're asking, well, how are you supervised? How are you reporting? Specialty occupation is also a big one. That is one of the most common RFEs right now, which at this point is almost like a cookie cutter for us to respond, because if you are asking me why a software developer or a doctor needs a bachelor's degree, it's a very easy response to me to provide that background to you. Like I have never heard about a doctor without a bachelor's degree, and it's illegal as you cannot do it. So sometimes, they just do it to make it more difficult, because the specialty occupation means that they are arguing that the position is not complex enough to require a bachelor degree, which sometimes, yes, there is a little bit of gray line, but for most of the position it's not, software developers or doctors or just professions that absolutely require a bachelor degree. Wage levels, they want to make it not not allow employers to use level 1, just never, which they already almost achieved that goal. Like almost no one is using the level 1 anymore. They went very aggressively after that in the last few years. Right now, honestly, in our practice, we're using level 1 only for the CAP cases, for graduating students, for someone who has, I don't know, I would say 1 year of experience, right? 1 to 2, which is, yeah, the level 1 is supposed to be used for entry-level positions. So that's the only time. And sometimes it applies. Like sometimes when you have a graduating student, you want to pay them just at the level 1. They don't have experience. You do have to train them. But the proposal, the changes would not allow employers to use it almost in any situation. And then that fee, I don't know if those of you who are sort of following the news, the proposed fee to have it $20,000 a filing fee to USCIS in some cases is just probably one of the ones that is going to be the most aggressively voted with and probably the least likely to come into light. I just cannot imagine that is pretty much scraping, right? Scraping the H-1B program off the face. And I think there's going to be a lot of companies that will stand up to it. There was a filing fee increase. So that was actually Obama's administration that did $4,000 fee for employers who have more than 50 employees and more than 50% of H-1B or L-1 visa holders. So we already have the additional filing fee for employers who are, who perhaps use a little bit more of the foreign workforce. And then I think $4,000 on top of everything else, on top of the other fees, I think it's a lot. So I do not know who came up with this $20,000. And then the last bullet point is probably also does not apply to many of you on the call, but it's removing the work authorization from the people who are waiting for their asylum, refugee, and TPS holders, the TPS, the protected status. So really the most, like when you think about it, the people escaping from persecution or escaping from some bad situation. The TPS is, for example, for, we had it recently not recently, a few years ago for Haiti during the earthquake, TPS for Nepal during the earthquake. So people who are escaping or they already here and they cannot go back, asylum and refugees obviously as well. So not allowing them to work when the case is pending for 3 years to get the asylum reviewed. I mean, what are they supposed to do here for so long? Like, how are they going to support themselves? So that also I included the last line. That is also cruel on that part. So this is the timing that we are looking at for the changes. It takes at least 6 months to implement new rules. So even if they started this week, that's exactly how much time they have. The president can still sign new laws until the inauguration, right? So that's until January. It's not at the election. That is just the decision. The good news is, and that's also what we are advising our clients, probably not the H-1B visa holders, but your employers, if they support the foreign workers population, to call Congress, to call your representatives, to make them aware of these changes. That's the White House is considering. That's what might be happening. Push back against it a little bit. But even if it comes true, the good news is that the new administration, if we have a new administration, the Biden administration, which we are hoping would be going in line with the Obama administration, who was very much for legal immigration. He was very much for smart, educated entrepreneurs sort of joining and staying in the US, right? He actually passed at the very end of his administration, it was already January, he passed one of those amendments to improve the I-140 applications. I don't know if that was the H-4 EAD or that was the job portability. One of those was he was really racing against time because he knew new administration is coming. And again, his policies were for legal immigration, just really supporting it. So we are hoping that Biden administration, if he comes in January, will be exactly the same. And they're going to have a little bit easier time scraping some of the rules because the new administration has 6 months to nullify any prior regulations without going through the new rulemaking process, right? So whatever is Trump passing right now, basically the last 6 months, the Biden was going to have also very, very easy time scraping it if he doesn't like, and especially if it's, ridiculous, obnoxious, and really sort of very difficult making, not only for foreign nationals, but really they will be thinking about how difficult it is for the companies who are relying on the foreign workers, H-1B visa holders. So that might be a little bit faster and easier just to nullify instead of just going from another 6 to 12 months for new rulemaking. So pending applications are typically not affected. So that's what we also talk to clients, for example, the STEM OPT extension, right? If we know that they might be starting the process of removing that, if you are within the period of time that you can file, obviously you only have a window of time when you can file it. If you are within that time frame, just file it. Just don't wait and sort of hope that things will be better. They're not going to be better. They might be worse for you, unfortunately. And, again, applications filed with USCIS, if we are talking about H-1B, if we have new rules about specialty occupation, about employee-employee relationship, they actually might be affected, right? They might be sort of the USCIS will applying that new rule or new interpretation of certain things and adjudicating or issuing RFEs in line with that. And final point is about the plaintiffs. So whoever is affected, I don't do litigation, but we do have very skilled, very dedicated, very passionate immigration attorneys who are also litigation. They just love it. They love litigating. They love going against the government and just arguing, citing cases, just telling them how wrong they are. But they always need plaintiffs. It's not like the lawyer can go to court without anyone. Someone has to complain. So both H-1B visa holders and your employers, even more so than the actual individuals, I can connect too. So if you feel like you would have a population of, potential plaintiffs, I can connect and I can recommend very reputable litigation attorneys, because we always say, like, unless someone pushes against it, someone has to fight for it. And immigration attorneys are fighting for it, but we need plaintiffs. Let me just review quickly if I wanted to indicate anything else. So we might be opening for questions very soon.
Yeah, we have, and thank you, Alexandra. It was a beautiful and to the point, absolutely to the point presentation. It's not always easy to meet an immigration lawyer or a doctor, as they say. You never know what they will tell, but it's better to know something and not be unknown and face the consequences later on. So in the chat we have. 2 questions. Are OPT visas affected?
Yes, so that's what we were talking a few slides back. The OPT, right. The first 12 months of OPT might have additional requirements, most likely some sort of reporting requirements, or perhaps also a training plan. And STEM OPT is the one that they are considering about removing.
Okay, and the next is, what kind of options are available if a principal applicant outside the country and dependents are in the country and order goes into effect?
Yeah, that's not the best. That's not the best situation. The principal, the option that is available is for the principal to come back to the US as quickly as he or she can, because just having dependents in the US will not really help in this situation.
Right. And will there be any effect on Green Card EAD or Green Card EAD renewal?
No, we do not hear anything with EAD connected to the Green Card applications.
Right. And are the H-1B renewal process affected? Yeah, somebody unmuted themselves.
So the
Sorry.
renewal process might be affected in a way that when we were talking about the proposed regulations coming for H-1Bs, we're tightening about the specialty occupation, tightening the employee-employer relationship, tightening the wages. So if someone is filing the renewal, let's say in a few months, maybe October, November, when we might have the new rule, then yes, the application might be affected. I don't know how much more difficult they can make it because it's already extremely difficult to get H-1Bs through. I think maybe they'll just unfortunately, deny more H-1Bs. But yes, unfortunately, the renewals will be affected, but again, not immediately. So whenever we hear, like, even if we hear about this executive order in the next, that's what we're anticipating in the next few weeks, that's not really affecting individuals in the US in any way. Just don't travel, and then you're not going to be affected for now.
Right. And relating to that question, what would be the status of H-1B holders who are outside of the US?
You do not have H-1B status when you are outside of the US. So if you are, again, the president has right to ban entry to the US. And if he says, I'm banning now for H-1B workers to come to the US, he has a right to do it until we have a new administration or until it's struck by the court. So unfortunately, the person who is outside of the US will not be able to come back. It's no longer in H-1B status. Perhaps you can make some arrangements with your employer to work remotely from your home country. I think a lot of people did that kind of arrangement. But yeah, there's no specific status when you are outside of the US.
Okay, is the new rule going to affect H-1B transfers, change of employer to people already in US if they want to switch jobs?
That is pretty much in connection to the previous question about pending applications. I just answered that two questions ago. And
right, yeah. I mean, I'm just reading out, the way you.
Yeah. Let's go through all of them. Absolutely.
Yeah, is the wage level increased for all the levels? I think
no. So we hear just the level 1 not to be used, which again, it's not going to change that much for most of the employers because no one is using level 1 anymore. Almost no one is using level 1. So no, we do not hear, at least not in the draft that we had access to, also that we are hearing. If they decide to make employers all across the board use level 4, for example, right, the highest level, maybe. I mean, if they really want it to be difficult, maybe that's going to say you only file it for level 4, which is really for very experienced individuals. They can do it, but I am not aware.
Yeah. Next, I don't know if this is a continuation, especially if they are waiting on administrative processing 221G. Not sure about that.
Okay, so that is for the individual who is waiting outside the US. I guess they cannot come back because they have this administrative processing. No, that's really doesn't change anything. It doesn't change anything. He will say the date. He will say the date in the executive order that from June 22nd, I am not allowing H-1B visa holders to enter the US for economic reasons. And unfortunately, when the person waiting for a visa, I understand, cannot come just because it's impossible, but it's also based on the draft that we're hearing, that person would be affected. If something changes that they say, no, only new H-1Bs, only cap cases, it's unlikely because he really wants to keep as many people out so that he can say to his base that, look, these are the jobs, these are the people who didn't come, I stopped them. So all of these jobs are for you. We're not going to give them to foreigners, as they say, unfortunately. No.
Okay. What happens to H-1B running out of 6-year period?
Yeah, that's a sort of a little bit outside maybe. That I would recommend that this person you know, schedules a consultation with me or another attorney that is really not connected to the part that we were talking today, because you do basically have to start a green card if you are running out of time. Usually during your 4th or 5th year, you have to start a perm application, the one that starts your green card. So that's a one sentence response. But I would suggest that the person who asked this question, consult an immigration attorney or speak to your employer if you are close to running out of time.
Okay. When will embassies reopen in India?
I don't know.
Yeah, when you are an attorney or a doctor, you should, the expectation that is, everything. Okay. How would H-1B transfers be affected? That is switching from one job to another before filing for perm during the next 3 months.
So nothing changes right now. Nothing changes in the next 3 months. They are applying the same rules, the same standard of review to transfers, to extensions, to amendments. Nothing changes. They would really have to go through the rulemaking, which they are planning, but it's going to take more than 3 months. It's really going to take closer to the end of the year. I think in November, we can start looking for that they might have a new H-1B rule coming out saying, now we have a new definition of employee-employer, and now we also are, just everyone has to use level 4. So nothing will be happening with H-1B renewals or transfers or extensions. If they are challenging, if you have a difficult RFE, it's just because that's the standard too right now. That's really nothing new. It is challenging and difficult adjudication process, but it's not that the immigration office would be applying the new rule.
Okay. Notice that H-1B fee might increase to $20,000 and more. How about H-1B amendment?
Yes, so that we do not know exactly on what type of cases that $20,000 fee might be applied to. That is one of those proposed rules that we feel it should be scraped off. It should not be really something that they will be considering. I do not know. Not the additional fee that we have right now for the $4,000 is only on new cases. When you are bringing someone new, it's not applying to H-1B amendments or extensions. So I don't know if this crazy $20,000 is gonna what type of cases they want to apply it to. If they want to be completely difficult and just make it absolutely miserable for everyone, they're just going to say you pay $20,000 on every single case, on every single extension, amendment, and transfer. I don't know if they're going to go that far.
Right. So we are on the last question. Anybody has any question, please write it in the chat. We have 3 more minutes to go. When there are no flights, how can the H-1Bs get back to US?
Well, depending where you're flying from, I mean, the flights are definitely picking up and the travel is picking up. And if there is no direct flight from your destination to the United States, you fly through London or you fly through some other hubs that are open. The flights are definitely reopening. I mean, that is, we are not in April, right? When we were in the middle of pandemic and really no one was coming out. We are in middle of June with reopening in most of the parts of the world. So I would just, if that was me, for example, if I had an H-1B, and I'm an immigrant too. I'm from Poland originally, and I had H-1B. That's what I always tell my client, that I know what you're going through because I went through H-1B, I went through I-140, green card, and naturalization. So if that was still me, if I was still on H-1B and I heard about this rule and I had my life here in the US, my housing, my kids and everything, I would just say, I'm just coming back. I don't know if I'm on vacation or whatever reason I am outside of the US, I would just find that flight to come back to the US.
Yeah, so true. People are saying thank you so much for the time. Of course, thank you for being so patient. So, and now at the end, as you said that you have been on H1B previously, so you know the pain, you know the what everyone else is going through. So you are a compassionate lawyer, no doubt about it. And thank you so very much, Alexandra. And I'll just ask the audience if you have any questions, you can unmute and ask, please. Usha, you have something to say?
Well, thanks a lot, Alex. It was wonderful. It was very crisp and precise. Thanks a lot. You just cleared everyone's questions, I think. So thanks a lot. Thanks, Julian, for organizing it.
Thank you for getting Alexandra to agree to do the webinar.
Yeah, thanks a lot. And I know it is very busy time for her, but still she agreed for this. Yeah.
Well, thank you. It was a pleasure, and thank you for the invitation. I'm happy to always chat and help anyone. And someone who also is, I see someone is asking for the newsletter link, so I think I have it here on this last slide, or it's just on our website, Capital Immigration Law Group. So thank you, everyone. It was a pleasure. If any questions and individual sessions, I'm happy to help.
Sure. Thank you, everyone. Thank you so much for joining in. And tomorrow we have our another webinar at 12 in the afternoon, 12 to 1. It will be on the future of web apps through JavaScript. And please join our webinar tomorrow and also day after tomorrow, Thursday. Another exciting topic, interpret black box ML models. So see you tomorrow and stay safe. Have a wonderful evening. Thank you, everyone.
Thank you. Bye.
Thanks.
Bye.
Bye.
Bye. Thank you.